Number one, Tax Equity Now, New York versus City of New York. Counsel?
Chief Judge Wilson, may it please the court, Richard Bress for Tax Equity Now, New York. I'd like to reserve 7 minutes for rebuttal, if I may.
Yes.
Thank you. Section 305 of the Real Property Tax Law effectuates a cardinal rule of tax law and Article 16 of the Constitution by requiring that all properties be assessed at a uniform percentage of their market value.
Are the two different, Article 16 and Section 305, or are they the same substantively?
We don't see any line between them, Your Honor. We think that one effectuates the other. One calls for the legislature to pass a law, the other is the law. We came here to court because the city for too long has violated Section 305. Assessments within Class 1 are grossly uniform within boroughs and between boroughs, and in Class 2, assessments for co-ops and condominiums are assessed at a far lower rate than rental properties.
So can I just be clear on the Class 2 argument? Are you complaining about the use of rent-stabilized buildings as opposed to, or rent-stabilized units as opposed to what it would otherwise rent for if it wasn't rent-stabilized? Or are you arguing that the use of rentals is problematic? So it's that the statute's the problem, that it should be sales that is the comparison?
Your Honor, we're not arguing that the requirement of 281 appropriately interpreted is a problem. So we're not contesting that condos and co-ops need to be valued as if the individual co-op or condo were a rental property. So the problem isn't the statute, it's how the city is interpreting and applying it.
So then you have no state claim with respect to that statute?
Your Honor, if this court were to rule, and let me be clear, both with respect to 581 and to 1805, if this court were to agree with the city and the First Department as to either of those, that they actually require how the state is applying them, then we do argue that there would be a claim against the state for a violation of Article 16. But if this court were to agree with us that how the city is applying them is not how it needs to apply them.
And where is that argument in the initial brief? I'm getting to the state's claim that
That it's somehow
you have not
dropped.
properly presented your arguments, and therefore we can't address them. With
Well,
respect to the state
we have
defendant.
argued in the first brief, Your Honor, that if 1805 or 581 meant what they claim it means, the city claims it means, then they would have a constitutional problem under Article 16. And as we've clarified in the reply brief, under this court's decision in Cass, a claim that a state statute is unconstitutional or that the state has violated, the legislature has somehow violated the Constitution, for that sort of a claim, the state is an appropriate defendant.
So if I'm understanding you correctly, then your argument is if as a matter of law, the city is correct that it can do this because it must, it must apply the system it's adopted because of the state law, then your argument is then that's the unconstitutionality of the state law, and that's why the state defendants are appropriate.
For both,
alternative
for both
argument.
Article 16, Your Honor, and the other federal constitutional claims, and for the FHA. But if this court were to agree with us that
Then
it's the
how
city's...
is it applicable to the city? If it's the, how is it applicable to the city?
I'm not sure what the it
With
is, Your Honor.
respect to if it's the statute itself which was passed and the city is faithfully following it, then
Your Honor, we would agree that if the question is whether the way the city, if the question is whether 305 itself, mixed in with 581 and 1805, is unconstitutional, that claim under Article 16 should not be against the city, and we would agree that can be dismissed as against the city. It really would be a state claim.
So let me just ask you this. The core of your argument with respect to the system is the disparities, right? That the one group carries more than its fair share than the other group, if I'm understanding,
That it's being assessed at a higher rate.
being
Right.
assessed at a higher rate. So what is the resolution of that?
So, Your Honor, we believe that to be clear, we think the state is wrong, the city is wrong to point its fingers at the state. We think both 1805 and 581 can and should be interpreted in a way that gives full meaning to 305, and it's just how the city's choosing to apply them.
I
That's
know,
the
but let me
problem. And so
interrupt
the
you here.
resolution-
I didn't think your position was that it has to be exactly equal numbers. I thought your position was you recognize that there might be some range, some play that's acceptable under the statutes and the Constitution. If I'm wrong about that, you'll correct me. So, but if I'm right about that argument, that is your argument, that sort of, how much of a disparity does the Constitution allow and the statutes allow?
Thank you, Your Honor. So I think perfection is not something we can reach as humans, in the sense that if you have 50 assessors going out and looking at 50 different buildings, they're all going to subjectively be somewhat different. You're not going to get true perfection. That we understand, and that, the state itself has accepted. There's a publication from the ORPTS called User's Manual for Maintaining Uniformity that discusses that very issue. But we think it's a different case when the city purposefully chooses to apply the caps with a consequence, the 1805 caps, with a consequence of creating disuniformity. It's like the Equal Protection Clause
Is the
in
guts
that
of your
sense.
argument about the caps really? So for example, I read parts of the complaint to complain about things like tax incentives.
Your Honor, our complaint, just to be clear, our complaint under 305 is really about,
Well, equal protection too.
okay,
right?
so as to equal protection, it would take in everything, Your Honor.
So that
because-
seems to me a kind of unusual view of the taxing power, because, tax breaks are frequently given to people in all sorts of circumstances to promote various social policies. And to say that's an equal protection violation
Your Honor,
is just novel.
let me be clear. I think the main thing is going to be the caps as to that argument. So let me be very clear about that. And if I may, just on the merits for a moment of these, it's the city that's brought 581 and 1805 into this by claiming that those absolve the city of failing to have uniformity in its assessments. Our position is that they don't, and here's why. So let's start with 581 because we were talking about it earlier. 581 does require the city to value a co-op or condo by what it would be valued for as a rental. What it doesn't require, and what the city is doing, is the city values each co-op and condo by reference to a particular apartment building that it finds, even if that apartment building is not actually comparable. Even if it's a stripped-down apartment building as opposed to a luxury condo or co-op, and even if it's subject to rent control, whereas under the ETPA, the condo or co-op would have priced out of rent control years ago. That's really the problem. It's how it's applying it, because in truth...
Isn't that a legislative issue and not a judicial one?
No, Your Honor, because the legislature has already spoken. The legislature has said in 305, it is a legislative issue, but in 305, the legislature has said flat out that all properties must be assessed at a uniform percentage of market value. So that's the base case. That's what you have to do.
Counsel, with respect to 1805, I know you were back on apartments, but I just want to
I'm
move ahead
happy to
first.
go wherever you'd like, Your Honor.
So you say that there is a legal way to apply the caps in 1805, but I know that the statute itself certainly doesn't prescribe a methodology for it, and it doesn't prohibit the methodology that the city is currently using. So how do we address that?
So, Your Honor, I think O'Shea, this court's decision in O'Shea answers a lot of those questions, because the court said in O'Shea, and I'll get exactly to where you'd like to go. The court said in O'Shea that nothing in 1805 prevents an assessing unit, here it would be the city, from complying with its mandate that no property be assessed by more than 6% increase over the prior year by reducing the target fractional assessment rate. That's a perfectly fine thing for an assessing unit to do in order to cure intra-class inequities. That's what this court said.
Right, I mean, in essence, you're really saying Judge Smith's dissent, which says there really is no limit because of the way that they can reduce it allows the city enough flexibility to eliminate the equal protection or the 305 disparity.
I think what we're saying is that this court's rejection of Judge Smith's dissent and saying that the city may simply reduce fractional assessment ratios in order to achieve intra-class inequity, that Section 305 then requires that they do exactly that. And the reason is this: you've got to reconcile two statutes. And when we think about reconciling, we think about, is there a way to comply with both? And the only way to comply with both of those is to reduce the target fractional assessment rate, complying with 1805, and that then complies with 305. If instead you do it the way the city's doing it, you're complying with 1805, but at the cost of grossly violating 305.
It occurs to me, though, that that might be a temporary fix. It might, in the initial, it might give you a smaller band of disparities, but over time, these assessments are going to go out of whack again. Do we continually?
Let me explain why not, exactly,
Okay,
Your
go
Honor.
ahead.
So how Nassau has done it, for example, is they've just looked at it each year and as need be in order to prevent the disuniformities have reduced it. It's now at 0.1. That's not a problem, by the way, because again, you're only reducing it as compared to what it was before. So you can go from 0.1 to 0.06 to 0.02 to 0.00, and you can continue that forever. It's just math. And there's no legal problem with doing it that way, and it really is the only way to comply with both. Otherwise, you really are gutting
O'Shea, I
305.
take it, you would say that O'Shea doesn't protect an increase, property owners from an increase in their taxes. It protects them from an increase in their assessment.
That's exactly what this court held in O'Shea, and that's correct, Your
And
Honor.
that is what drives your argument.
Right. And so whereas the city on both of these accounts is pointing at state law as to both, we're really just saying, no, no, no. Both of these state laws allow you to comply with 305. It's just how you're applying them leads to a gross disuniformity, which is in violation.
So I don't know what your federal equal protection argument gets you over your state argument. One thing that concerns me about it, though, is Nordlinger, and I'd like you to address that.
Of course, Your Honor. So if this court agrees with our state statutory argument, we think Nordlinger is not an issue for us, because at that point we think we're in Allegheny-Pittsburgh world, Your Honor. In Allegheny-Pittsburgh, there was a constitutional provision and a state law provision in West Virginia
Yeah,
that
but I'm
required...
really asking why Nordlinger doesn't put a crimp in your federal argument.
That's what I'm getting at, Your
Okay.
Honor, is that, I'll start with Allegheny-Pittsburgh, go to Nordlinger, and explain how they work together. So in Allegheny-Pittsburgh, which was, again, the West Virginia case, the court held that there was no conceivable rational reason for what the assessor was doing because state law required uniformity, and there wasn't a state policy to allow something different from that. Nordlinger came along, and there wasn't any such state law requiring uniformity, and they said that's just a different case. In fact, they said Allegheny-Pittsburgh is the unusual case where, because state law is as clear as it is, there isn't a conceivable reason. And we know that it means that because years later in 2012, in the Armour case, A-R-M-O-U-R, the Supreme Court said that Allegheny-Pittsburgh was the unusual case where a clear statute had been clearly and dramatically violated. We think that's this exact case, Your Honor. So we think there would be an federal equal protection case. We also agree with you, Your Honor, that in a way, if we win on the statute, it doesn't matter very much because you get to the same result.
So can I move you over to your substantive due process claims for a minute? Because I don't really understand what the protectable interest, I assume it's substantive due process, although maybe I'm wrong.
No, it's not procedural, Your Honor. It is substantive, and it requires effectively, Your Honor, as the courts have said, that we demonstrate that it is so unreasonable and so arbitrary as to not be an exercise of the taxing power at all and to be something else akin to confiscation.
That seems a lot harder to win than your equal protection
We
or
agree with that,
statute.
Your Honor.
Okay.
It's a lot harder to win.
Okay.
Can I drill down
May
a
I
little bit on your
follow-
equal protection claims? What are the makeup of the classes? In other words, when you're looking at Class 1, are all Class 1 homeowners in the same class? And where are we talking about the impact of race? Is that only in fair housing, or
So
are
that's
you-
only in fair housing, and I'd love to discuss that when we get to it, Your Honor. But as to this, it really is the homeowners who are not protected by the cap system under 1805, if this court were to say that the city's handling that correctly. That would be the class, Your Honor. Now, as to, just to be finished that thought, on 581, there is no rational basis at all for valuing a condo or co-op by reference to a rental apartment that everybody agrees is completely different and lacks everything that makes that co-op or condo valuable. I don't even know how they would try to uphold that under equal protection. Now, as to the FHA, Your
Sure,
Honor,
they're going to tell us.
I'd be excited to hear, Your Honor. As to
Maybe
the
before you
FHA,
move to the FHA, I think Judge Halligan had a question.
I did, thank you. I just wanted to follow up on your exchange with the Chief Judge and equal protection. If we disagree with your reading of the statutes, does anything remain of your equal protection claim, or are you then in Nordlinger as opposed to Allegheny?
Your Honor, if you disagree with us on the statute, then I think there's something left to the equal protection claim because this differs from from Proposition 13 that was at issue in Nordlinger in the sense that this statute, 1805, doesn't reset once you sell a property. And there really isn't a rational basis that we've heard of yet for allowing a property in perpetuity to benefit from the caps. That doesn't satisfy any of the reasons that the state or city has put forward here for its rule, which is that homeowners who have been in a house for a long time shouldn't be subject to a sharp increase in assessments that they can't afford. That absolutely can never be true when you hold that cap steady even when they sell it. So there's still an equal protection problem there, and we think there's still one with 581, Your Honor. And I'm sorry, I didn't see you over there, so if you were trying to speak earlier, I apologize.
No, I appreciate it. Thank you.
You're quite welcome. So I don't know if I'm running short of time, Your Honors,
You want to
but
address the Fair Housing Act?
yeah, I'd like to. Thank you. So there's a violation of the Fair Housing Act here, Your Honor, as to both Class 1 and Class 2, because as to Class 1, as we've alleged, the tax system as it's run right now has led to a situation where homes in majority minority neighborhoods are being assessed an extra $1.9 billion, an extra $376 million in taxes, as compared to if they were a majority white neighborhood, based on how these work out. It is a disparate impact that is a strong one. And as to rental properties, they are being subject, because of how the city is running this, to an effective tax rate that's 7 times as high as for co-ops and condos. And rental properties, unlike co-ops and condos, the residents are predominantly of color.
And
Now-
how is it with respect to the stage of the proceedings? Are we to look at all of these?
Thank you, Your Honor. So the court below looked at this and really applied a heightened pleading standard. We think that that's just a mistake, and every court that's looked at it has said that's the wrong way to think about it. It is true as a substantive element that there is a robust causation that's required substantively, but in pleading, all we've got to do is what you usually do in pleading, which is we're given the benefit of, all reasonable inferences, et cetera. And the question is, have we plausibly alleged facts that would demonstrate here the strong causality that's
Well,
necessary?
why aren't they right, that's me over here, why aren't they right, that's fine, when they respond, even if it was a factor, it's one of many, and it may not affect any particular homeowner or neighborhood or community in any particular sense, and therefore you can't satisfy, even accepting all your factual assertions as true, you won't be able to satisfy the pleading requirement.
So, Your Honor,
And by the way, I wanted to ask you...
we have
when-
shown that it applies to particular neighborhoods, so let me be clear. I mean, if you looked at, Canarsie, for example, versus Park Slope, and you've got, probably a multiple of 4 in terms of what the effective tax rate is there, and one is majority minority and one is majority white. We've got statistics really coming off the pages in our brief demonstrating that majority minority neighborhoods are being assessed taxes at a far greater rate, properties in those neighborhoods, than properties elsewhere. Where the city is wrong and Robinson was wrong is in arguing that, well, there's white folks in these areas too, and because they're also going to have the higher tax rates, therefore we don't have a claim. This is a disparate impact claim. It's not an intentional discrimination claim. And all we've got to show is that there's a disparate impact on minority homeowners and renters, not that there's an
Yeah,
exclusive
but
impact
I
on
thought their argument, they'll correct me, of course, once they get up. I thought their argument, at least in part, was that you can't really make this argument for the robust causality because there's too many factors that go into these choices about purchasing a home, what neighborhood to live in, that it gets so thin that you cannot meet this.
And Your Honor, I think that goes to, and I'm glad you asked it, it goes to causation, and is our causation tight enough, if you will? We believe it is. So as to homeowners, for example, higher property taxes add to the burden of a homeowner, and we have alleged, and we think quite credibly, that this contributes to the higher rate that exists in these communities of foreclosures. Now, yes, of course there's other factors, but we don't think we have to demonstrate it's the only thing. If it's the straw that breaks the camel's back and we're prepared to prove that, then we think we've alleged enough as to...
So one of many may work. Let me just ask you one thing, because your red
Yes.
light is on, because you said the courts applied a heightened pleading standard, but you don't mean they're applying like an Iqbal heightened pleading standard.
So Iqbal, we think, is basically fine, right? I mean, if we just have to prove that our claim is plausible, have to not prove, have to allege facts demonstrating a plausible claim, we think that's fine. What the court below seemed to think is there was something more necessary, and we don't think so. And briefly, as to renters, the city has admitted that the higher property taxes imposed on rental buildings discourage developers from producing rental buildings, and we're talking about a city that has a housing crisis. So we think we've alleged more than necessary to show that these policies have rendered housing unavailable disparately to minorities.
Thank you.
Thank you.
May I just follow up, Chief, briefly on that answer? Is there a different challenge that you face meeting the causality standard with respect to showing perpetuation of segregation as opposed to that there is a racially discriminatory impact in either Class 1 or 2?
Your Honor, my understanding of the law here is that there's two ways of showing, and you can show either of them, discriminatory effect. One is by showing a disparate impact, and one is by showing perpetuation of segregation. We think we've done both, but as far as perpetuation of segregation goes, we think that we've demonstrated most clearly by our allegation that the heightened taxes in these majority-minority communities discourage whites from moving into those communities, make it harder for people to make a decision to move into those communities, and perpetuation of segregation goes both ways.
Thank you.
Thank you.
Good afternoon. May it please the court, Eden Burkett for the City of New York. Your Honors, the city respectfully requests that the decision of the Appellate Division First Department be affirmed. It correctly held that there was no legally actionable claims in the complaint, and that the gist of the complaint, the gravamen of the complaint, is a disagreement with the duly enacted statutes by the legislature, which have been faithfully enforced by the city.
Counsel, if I may interrupt you, I think you're correct in this sense that, yes, if they say, we have a better way of doing this, right? They could say that, we have a better way of doing this. That might not be enough, but they're really saying there's a better way of doing this that this court has perhaps pointed to and said is permissible, and the reason that you have to do something else, whatever you choose, it may not be what they want, is because of the result, the inequalities, and that is what the city, yes, the city and state can choose to do whatever they want to do, but they can't end up with these inequalities. That's what's prohibited by the Constitution and these statutes.
Well, with respect to the idea of the outcomes, that there is no constitutionally protected right that they've identified that a taxing system, especially one as complex as the one in the state and in the city of New York, that there should be equality of outcomes.
Well, let me ask you this on that. So let's say you've got a house in the South Bronx that's market value, and no one disagrees about the market value. Let's just take the market value. I'll just make up a number, $500,000. and then there's one in, let's say, Chelsea, also at 500,000, that they can end up paying different taxes before caps, before abatements, before all of that, just that number that you come up with. How is that permissible?
Before the caps?
Yes, when you're figuring out I forgot the term, I'm sorry, the taxable amount, when you're doing your fractional share, and you come up with a number that's the assessment.
Well, maybe I'll just sort of provide a little sort of overview in terms.
And forgive my inability to
no,
perhaps
no,
understand this very complex
It is very
taxing
complex.
system.
So the first step is the determination of the market value. Now, there is some limitations placed upon the market value. For example, the assessor is not permitted to consider the conversion potential, some sort of, redevelopment potential. It's supposed to be assessment of current use and occupancy under RPTL 302. But depending on different properties are typically valued in different forms. Class 1 properties, mostly 1 to 3 family, they're typically valued based on sales, whereas most other properties are valued based on the income capitalization, sort of what the net income with a capitalization rate. So
Well, that's Class 2, right?
That's
And
for
sales
Class
is
2.
Class 1. You don't do that Class 2, or at least the condos in co-op, you don't do them by sales. That's part
correct.
of
No,
the
well,
issue.
and it was nice to hear council acknowledge that sales are not permitted in the valuation of co-ops or condominiums because there's a lot of references to sales in the complaint. And
I guess he could correct that. I didn't hear him say that sales are not permitted. I thought he said it's not required.
okay,
You
well,
could do a rental comparison.
you could ask council on
clarify.
rebuttal. But it is true that and it's been held multiple times by this court, especially in the Diaz Alamo case, as well as in the Green Tree and at Limbrook case. Those cases, which also cited other precedents, especially notable is in the Green Tree matter, this court cited with approval the Second Department's decision in South Bay development, which recounted a long detailed history of co-op and condominium valuation and confirmed and this court agreed that the legislature in enacting Real Property 339Y, which applies under the Condominium Act, as well as RPTL 581, reaffirmed that residential co-ops and condominiums are to be valued as if they were apartment houses with rent-paying tenants.
Could I move you back to what I think was Judge Rivera's question? And I understand that there are caveats like that can affect things, but assume that you've got two houses that are identical in all the terms that matter, so their market values are identical, and one's located in Chelsea and one's located in the South Bronx, and they're Class 1. We're just dealing with Class 1. Do you read Foss to say, first, that both of those must be assessed at their actual true market value?
Well, I hesitate to say that Foss would.
All right, the statute, the Constitution, anything you like.
Okay, well, so Foss is very, very different, I think, in terms of that.
Let me not complicate it with Foss. Must those be now valued at their true market value?
The requirement is that properties be valued at full value.
And they must be multiplied by the identical assessment percentage.
Correct. That would be that would typically referred to as the assessment ratio.
Right. And so the assessment ratio times the market value for those two properties should produce identical numbers.
If they had identical market
Identical
values,
market
yes.
values, right? So, but they, in Judge Rivera's hypothetical, and I think in the pleadings, they don't. And there's, I think, evidence from the city that like properties don't. And as the plaintiffs allege, that's a function largely of the caps. Would you
Yes.
agree with that?
Well, so there's a chain of operations. There's an order of operations. So there's the market value, then there's the level of assessment. This is 6% for Class 1 since for the past 15 years or so. 45% for the other three classes. So you have the market value, you have the level of assessment. This is on all of the notice of property values, all the tax bills. There's no dispute. I don't think that the city is somehow assessing certain properties at 7% or 5% on that level. And then you have the application of assessment caps and exemptions and abatements and any number of things. And then you have your final tax liability. And if you divide that tax liability by the market value, you have the metric that is so frequently.
But can I try something? I think Judge Rivera's initial hypothetical, unless I'm wrong, was absent the cap effect, right? So I think the chief judge is asking you, okay, you're alleging caps, right? They're alleging certain caps will affect the numbers of the ultimate tax. But the assessment, the first part of what you're talking about, up to you get a tax bill at X, those should be the same for those two properties?
At the level.
Before the caps are applied?
Yes, and I don't think there's an argument that they aren't. Their argument, the appellant's argument is that they're looking at after the caps, which of course they're going to be different because property values appreciate differently in different parts of the city. And so
Right, and so their argument is, and as you said, the assessment ratio is now 6%, that if you reduce the assessment ratio to 0.6%, the caps wouldn't apply. Do you agree, just as a factual matter, that if you were to do that, that would be true? Caps wouldn't apply?
if you reduced it by that much, I would assume so.
Okay. Is there anything in the law that prevents you from doing that?
Well, I think that appellants are right that this court in O'Shea found that it was, that the level of assessment is a discretionary determination, and under the plain language of 18051, it's the assessed value, not the market value, that counts, and it certainly, you could essentially frustrate the spirit, at least, of 1805 by adjusting down the assessment ratio.
Well, that, when you say frustrate the spirit of it, that assumes a different outcome in O'Shea. That is, if the court in O'Shea, and you could disagree with me if you think there's a reason to do that, or even if you think O'Shea was wrongly decided and we should reverse it, but in saying that the city is free to reduce the assessment ratio, or any municipality is free to reduce the assessment ratio as much as it wants, that only the assessment is protected, not the ultimate tax, that that decision, in your words, I guess, frustrates the spirit of what you think the legislature was after.
Yeah, it was one of the very first things, clearly going back to the passage of the 1981 package, the legislature was obviously, this court correctly found that the legislature wanted to prevent a dramatic shift from commercial properties onto residential properties. But the legislature also, in enacting the assessment caps, specifically said that they wanted to protect against economic dislocation and to provide stability against dramatic assessment increases.
And those arguments were made by the losing side in O'Shea about the legislative history and the spirit of the legislation and so on. Yes,
and I think that the court's analysis of O'Shea seemed to depend, and most of the decision was about the peculiarities of the situation in Nassau County at the time. So if I had to hazard a guess as to why the decision came out as it did, it hinged primarily on the fact that the assessing system in Nassau County had the assessed value, or the implied market values based on assessed values, had gone so far out of whack from the actual market values, and that pursuant to a stipulation, Nassau County agreed that they had to do a full market revaluation of all the properties, and in order to equalize the the disparities that had arisen from the fact that they weren't doing annual market values for 70 years. They were, even as of the 90s, they were using 1930s era construction costs and 1960s era land values. So properties were so undervalued that in order to revalue them, the new market values would be so much higher, that if the assessed value caps under 1805 were to apply, it would take decades, hundreds of years in order for the properties to reach some sort of alignment. So even if it violated the spirit of the law to allow the assessor to use the lowering of the assessment ratio to, that people's actual taxes could double or triple, which is a concern that the dissent raised, that it was technically in compliance with the letter of the law. But I think that the problem, which I think Judge Cantaro pointed out, was that lowering the assessment ratio, isn't that just a temporary fix? And that's exactly some of the experts that appellants point to, especially a man named George Sweeting he was at the Independent Budget Office, and they cite extensively from a 2006 report.
Well, let me ask you this. Is it the city's view that what it does in this system, the way you have interpreted the statutes, the constitutional requirement, the way what the system you've adopted and the way you apply it, does not result, that's not what results in the disparities? Is that your position, yes or no?
Well, I think that the disparities come from the fact that this is an ad valorem tax system. The assessments are downstream of market values, and market values are not equal. And the fact that property tax burdens are not the same is not a.
No, I'm sorry. I'm going back to my hypothetical. When the market value is the same, I don't think anyone's talking about when someone's got property that's worth a very different number from another piece of property and trying to compare those. Property that's got the same market value.
Well, I think it all depends.
I understood so many comments by city officials that you all conceded that these disparities exist because of the way you apply the system. It's just you believe that the law either mandates it, permits it, it's not unconstitutional. But so I'm just trying to clarify that.
I think that there is some, I certainly think that most people would agree that the system as, the law is really, if there is a disparity, it's at the level of the policies of the legislature.
So it's not your application?
It's not due to some sort of arbitrary application, and I see that my time is, I want to sort of touch on some of the other questions.
Before you do, counsel, I'm sorry, I'm having a little bit of trouble still wrapping my head around this subversion of the intent of 1805 argument that you're making. And is it your position that the application of caps is the legislatively mandated way to address these disparities, as opposed to some other method, such as greatly reducing the fractional assessment?
Well, that was the policy that the legislature chose to prevent this economic dislocation and to create a stability in the tax bills.
Might there
really.
not be a better way that's not prohibited under the statute?
Well, I don't believe it is prohibited, and I don't agree with appellant's argument that RPTO 305 somehow requires some equality of outcome. The RPTO 305, it legalized the then existing assessment practices, which had been the subject of heated discussion throughout the 1970s, including Nassau County's.
Well, I know your light is red, but I just want to get back to, I don't think they've argued equality, but of course they can challenge that or say otherwise on rebuttal. But I am a little bit struck by part of what I understand to be your argument, and you'll correct me again if I'm misunderstanding you, your argument being that you can have the types of inequalities, these disparities that they have comprehensively described and that public officials have referred to in reports and studies and in the media, and that there's nothing wrong with that because it's an ad valorem system. And I don't really understand that particular argument, because I understand that to mean that you can favor one group on the backs of another. I don't think the Constitution or the statutes permit that.
Well, I mean, if the argument is that it violates equal protection, I think that it's not a good argument, especially because of Nordlinger, which said that, you know, and this.
Well,
court's-
I mean, I'm not even on the equal protection argument. I'm on the reading of these statutes as to whether or not that could be an acceptable outcome under the statutes. Yes, you want to, of course, it's a legislative choice to protect a particular group. Here, we're talking about Class 1 homeowners. The question is, can you then shift that tax burden to another group so that they're carrying more than their fair share? I thought that was at the core of their argument. I may have misunderstood them.
I mean, I think that was initially something that came, the class share system, for example, under
Yeah.
1803. That seems to have been de-emphasized in their briefing before this court. I think that the core argument involves 305, 1805, and 581. I don't.
And the FHA claims, which if you would take a minute or two, even though your time's up, to address those, that would be
I
great.
wanted to briefly mention that. I think it's very important to note that what's notable about the FHA claim is that they cite everything except for FHA claims against a taxing system. That is a truly novel claim, and they can only come up with 2 trial court decisions. They can't find a single appellate level decision that's found that a taxing system.
Well, then,
is
if
subject-
it's novel, unless you're going to argue it's completely foreclosed, why don't they survive a motion to dismiss? It doesn't mean they'll eventually win or persuade anyone on what you're calling a novel position.
Well, it's because I think that first of all, the appellate level precedents such as Robinson and Housing Justice Campaign are important to recognize, but I think that you also have to look at the purpose of the FHA, how it was drafted, how it's been applied for the past 60 years. It's quite significant that there's not a single, they can only point to 2 lower court decisions that are really absent, that are really notable for the absence of any persuasive logic as to why it would apply to a taxing system. Because again, taxes are against property.
Seems to me that would be one of the most effective ways to argue the statutory protection, because the statute, of course, is concerned not just with individual discrimination, of course, but its broader impact, and is meant to be interpreted broadly.
So there are numerous problems. Number one is sort of the actual language of the statute, but also going back to the Inclusive Communities case, where the Supreme Court not only said there had to be a robust causality, but that the claim at the pleading stage, and that it should be resolved at the soonest possible opportunity, had to connect, again with robust causality, to a specific policy that has some sort of arbitrary, invidious discrimination that could be remedied by a court order. Here, what we have is we have duly passed state statutes, which again the legislature has almost nearly unconstrained discretion in drawing up the lines of taxation, and that the appellants simply haven't pointed to a specific policy, some sort of aberrational policy, which again is is significant. Really, what they're pointing to is the sort of the outcome of a taxing system that's being enforced in compliance. They haven't pointed to any sort of aberrational enforcement policy or some policy that the city has created, and the First Department had a very good sort of analysis that they haven't pled concrete facts tying to any specific policy. And
So you think the pleading as regards the application of the caps is not specific enough to demonstrate, at the pleading stage to establish causality.
No, I don't think so, because again, it's broadly applied. It's not some sort of discretionary policy. It's simply the mechanical application of a policy that the legislature certainly has authority to create assessment caps.
Well, it has authority, no disagreement there, to make those kinds of legislative choices, but the FHA does place limits on how far you can go. You can't do it in a way that has the kinds of disparate impacts that they're alleging. You may say that there's no, right? Your
Well-
argument is they haven't established causation. Can you address, I know, if
Well,
the Chief
I-
Judge will allow me, if you could address even briefly, because you got your red light, this question of how significant this factor must be if you're talking about multiple factors that affect someone's decision to buy or rent in a particular neighborhood. 'Cause I understood that was in part your position, that you can't really disaggregate this particular factor, the tax burden.
Yes,
right?
exactly.
From all the other factors that go into making these kinds of perhaps very personal decisions.
Yeah, I think the First Department adequately addressed this, that people live in different parts of the city for any number of reasons, and to pin it on the tax system is without anything further. It just simply is too simple. And I think that the other point that was raised by the First Department was that one of the themes of the complaint is that is drawing these sort of simplistic, almost cartoonish sort of examples of, majority-minority neighborhoods being sort of over-assessed allegedly, and then majority, supermajority, non-minority neighborhoods. But the sort of the end result is that they want these neighborhoods that they want to integrate, allegedly, they want their taxes to go up, which seems like an odd way of if there was this issue of segregation, that somehow the tax burdens was like the definitive factor or some overriding factor
Well,
aside
it
from
just,
everything else.
I thought in part that argument was, it just means that the tax burden is equalized across neighborhoods, and no neighborhood is, or home, is benefited or favored over another. And that's how you even that playing field.
Well, I mean, I think that they can claim that, but it also, I think, in terms of like the pleading standard, they have to, they not only can't make legally conclusory claims, but they also can't make facts that are flatly contradicted by the record. And the record that they cite, including the 2006 IBO report, I'll note that it was page 31 in that report. It has a nice chart that shows that since 1984 to 2007, which is the date of the report, that the effective taxes in majority-minority neighborhoods such as Brownsville, Bed-Stuy, Crown Heights, Morrisania, went from having the highest tax rates in 1984 to the very lowest in the city in 2007, which, again, like their theory of gentrification is backwards. Their theory of gentrification is that non-minority neighborhoods are appreciating faster when everyone kind of knows that over the past 40 years, that hasn't been the case, and that certain areas that are primarily minority have appreciated tremendously. And the idea that those residents who have had the benefit of the caps all these years are somehow being harmed by the caps, it is just simply, it's just contradicted by the record, and as well as in the record itself, at page 207, there was a testimony of
But
George.
again, you're looking at pleadings at this
No,
stage.
sounds like a
Simply-
summary judgment motion you're arguing right now.
Well, but I think that the pleading standard, I think, is also that if they're making claims that are contradicted by their own statement, their own records that they're integrating into the complaint, and they even annex as Exhibit E to the complaint, it's page 207 of the record, a testimony of George Sweeting, which basically, if you read they offer it in support of their claims, but if you read it, it essentially says, this is all the legislature. This has nothing to do with like the city's aberrational enforcement, that co-op and condos are required to be valued based on sales, and that the lowering the assessment ratio would have almost no effect, and that, and in the IBO report, perhaps not in the exhibit, the same author said that essentially the effective tax rates in majority-minority neighborhoods have went from being the highest in the city to the lowest.
Thank you, counsel.
Thank you.
May it please the court, Mark Rube for the State of New York and the New York State Office of Real Property Tax Services. The state defendants are not proper parties in this action because the legislature has given authority over assessment decisions to local assessing units acting in accordance with local needs within the parameters of state law. Plaintiff does not identify any injunctive relief against the state, does not identify any involvement by the state, does not even refer...
What about his alternative argument, that if we were to agree with the city that this is what the law mandates, requires, his argument here, the plaintiff's argument, that would mean it's unconstitutional?
Well, that's reads to me as a constitutional avoidance argument,
Okay.
except our interpretation, because otherwise there'll be constitutional problems. But I'm happy to talk about the statutory scheme and explain why it is constitutional. Starting with the caps in 1805, those provide protect homeowners from in rapidly appreciating neighborhoods from fluctuations in assessments. And that's precisely the kind of rationale that the Supreme Court in Nordlinger found supported the scheme there, even though
But it doesn't protect them from rapid changes in their taxes.
That's great. I mean, nothing, because towns have discretion, they decide the levy. So the ultimate tax, the assessments determine the ratio that you will bear, and the levy determines the ultimate liability. But to your point, the rational basis doesn't require a perfect fit between the legislature's purpose and the means of achieving it.
So does it go to their application and not, it's not a result of what the state legislature did, it's the application of the city?
Well, I wouldn't even say it's the application. It's the local assessment decisions made by the city within the parameters of state law. The state law provides...
So are you saying the plaintiff is wrong, that it's how it's being applied that's causing the problem?
No, that's not what I'm saying. I think plaintiff agrees that their alleged violations can be remedied consistent with state law as it stands, which is solves any sort of constitutional
They can
problem.
be read in harmony together.
They can be read in harmony together.
Yeah,
And-
because you, as I understood your brief, you take no position on the contentions against the city and whether or not the city has violated the law, correct? Or am I misunderstanding now? what you're saying?
Yes, I mean, we didn't take a position. We didn't take a position on the constitutional question. This court in matter of State Board of Equalization and Assessment v. Kerwick stated that the state and DTF do not have authority to direct substantive assessment decisions, that the state and DTF's role is to advise and aid in assessment, provide guidance. So I can talk about the statutory scheme and why it's constitutional, but given that deference to local decision-making, the state has not taken a position on the constitutionality of sort of particular practices. With respect to 581, I understand plaintiff to be challenging assessment decisions essentially made by individual assessors, what comparable buildings they chose for rentals, for condominiums and
Well, there's
cooperatives.
a higher level policy on that, right? There may be like individual buildings, but there's a higher level policy on
Right.
that condo and co-ops that they're talking about, which is it's a challenge to a systemic approach.
Right, and so there's a high level of policy that they are talking about with respect to the comparison to rent control buildings. And the statute doesn't say one thing or the other on that question, and DTF's guidance also does not say one thing or the other. I think the city is relying on this court's decision in matter of Green Tree, and this court can clarify what it meant in matter of Green Tree.
Let me ask you the same question I asked counsel for the city. Is there anything in the state law that would prevent the city from reducing the assessment ratio rate for Class 1 tomorrow from 6% to 0.6%?
That would be consistent with state law. That is what happened in matter of O'Shea and Nassau County, though of course there was a stipulation compelling Nassau County to do it. There's no stipulation compelling the city, so it's a policy tool available to the city. It's permitted but not required.
Permitted by state law.
It's permitted but not required by the state statutory scheme. Speaking to the state statutory scheme, I just also want to note, I'm not sure if I heard this correctly, but I thought I heard Mr. Press say that essentially, if you agree with our statutory argument, there's a constitutional problem, that the constitutional argument hinged on their interpretation of Section 305. And that's precisely a reason why the court can avoid a constitutional question by not adopting that interpretation of 305, reading them together harmoniously. I still don't think I understand what function 1805 serves under plaintiff's statutory reading. Under the state's reading, it protects homeowners, provides a cap, but as Your Honor noted, local governments have policy tools lowering the assessment ratios available to them if they want to mitigate any disparities that arise from the caps.
Which retains the protections the legislature intended from the cap, because you're not changing the cap. Am I understanding this correctly?
Right.
But you're avoiding a tax burden shift or a type of disparity, an inequality that might indeed violate the Constitution or some other provision of the statutes, yes?
That's correct, Your Honor. I think the effect is that lowering the assessment ratio, everyone still benefits from the cap,
Yes.
but there's sort of less disparity in terms of how much, I think the disparities arise from particular groups benefiting more from the cap
Yeah.
than others, as happens with any cap on a tax.
And then they've got to do something to balance their budget?
No, because, I mean, the levy is sort of independent of how all these assessments work. The city, any town in New York, they decide, it's kind of reverse math. How much money do we need?
Right.
And then they look at the assessments and be like, how are we going to
So if you
divide them?
reduce the assessments dramatically by, by taking 6% and making it 0.6, you inevitably have to increase the tax. I mean, that just seems like simple math, right?
Right, I mean, if you uniformly lowered everyone's assessment, let's make the math easier than Your Honor's hypothetical. Let's use 100,000. Every property in New York City is worth 100,000. And then you lower the assessment ratio so that it's 10,000. Well, then you'd have to increase
Tax
the
everybody
tax
at
rate.
50% or
And
something.
everyone would end up paying the same tax, even though their assessment was
It's not really the same, though. It's a mitigate, it reduces it to a mathematical, non-distinction.
Right.
It's not really equalizing the assessments, it's just making them less pronounced, isn't that?
Yeah, I think we're also we're oversimplifying in our hypotheticals because there's also assessments, abatements and exemptions
Yes.
and other things that affect the underlying tax bill apart from what we're talking about, the caps. And that's sort of the problem with plaintiff's constitutional argument is that if you look at the end result and say, look at the underlying tax bill for two different properties that value the same and maybe have different tax bills, that doesn't tell you why they're different, which policy tool, which part of the formula made that difference. And that's why in the constitutional analysis, courts look at whether the
Well,
formula.
what would be a permissible factor for that difference?
Permissible
It's not
factor?
going to be race, it's not going to be the geography, what would
sure.
be a permissible factor?
Sure, so for example, the caps, we talked about preserving stability.
Yeah.
Section 581 encourages homeownership. That was enacted in 1981 at a time when many rental buildings were considering whether to convert to condominiums or cooperatives. And Section 581 says they shouldn't be penalized for a decision to convert to a condominium or a cooperative because we want to encourage home ownership. And so that's why,
I guess what I'm, and it may again be that I'm not fully appreciating the complexity, even though the stellar briefing on that matter, right? That if you have a policy choice, as you say, to encourage home ownership, to stabilize homeowners so they don't get these spikes.
Right.
Does that end up, because at some point, you got to pay for your services, you've got to do something with your budget, that renters end up paying more than their fair share?
well, I'm not sure that's exactly the case. I think we haven't really
And
talked.
particular homeowners end
Yeah.
up paying more than their fair share.
Well, I want to emphasize that 581 also protects renters and tries to provide equality. We haven't talked about subsection 3, which I think was previously subsection 2, but that is the provision that says that rental buildings should not be assigned a premium because a developer might want to pay more for a rental building to convert it into a condominium or a cooperative. And so rentals cannot be valued assigning that sort of premium. So it's trying to maintain equality between rentals and condominiums and co-ops. And that's plainly rational, and the use of particular comparators is a local assessing decision that the state leaves to local government. Unless there's further questions, I see my time is up, and we ask that you affirm the dismissal.
I'm sorry, just, yes, I want to get back to this, I'm sorry, sir. I know your red light is on. To your, I think it was your first point, that their claims against the state are not properly before us because they didn't make the arguments in their brief. I
Right.
just want to get back to that. What is it you say is missing from their initial brief that would have sufficiently presented to us, in your opinion, the argument against the state?
Well, I mean, there isn't any argument that the state is and it doesn't ask for any conceivable form of injunctive relief against the state that would remedy the violations. Even as to the constitutional arguments, that I don't read them as constitutional challenges, but arguments that their position should be accepted as a matter of statutory construction to avoid constitutional issues. And I think in their brief, they cited pages 39 and 40 of their opening briefs as preserving their arguments against the state, and I don't, I looked at it and I could not understand
They
why.
were asking for declaratory as well as injunctive relief.
Yes, so to the extent that the court considers that there is an active constitutional challenge, the state is here and that issue can be resolved right now. But to the extent that there are any proceedings going forward, the state has no proper role in those.
So to be clear, counsel, if I can, your position is that if there is an active constitutional challenge as opposed to an argument that a statute should be construed a particular way because of constitutional concerns, that the state is a proper party?
Well, I don't want to quibble about the capacity. I think technically, generally, the state has discretionary authority to intervene, and in the Foss versus City of Rochester case, the Attorney General participated pursuant to Executive Law 71. Here, we're defending the constitutionality of the state's scheme, so we don't think sort of the capacity is material right now. The main point is that going forward, there's no role for the state. Unless there are further questions, thank you.
Thank you.
I will try to move quickly, but I've got a number of things I'd like to at least clarify. I think it would help the court. To start with, in Cass, the state, there weren't any injunctive claims made with regard to the state. The court just simply said the dismissal of the state was improper because the state is a proper defendant in a case where you're challenging the constitutionality of a statute. So if you were to disagree with us on the statutory claims here and our constitutional claim were to go forward under Article 16, the state would be an appropriate defendant. Otherwise, we're happy to let them go. So as to what we're challenging under 581, we're not challenging individual assessors' decisions here. Now, the state's in an unusual position because they're saying it's not our fault. These are local assessment decisions. But they're a local assessment policy. The city believes, and you can get this if you look at page 207 to 210, page 228 to 230 of our appendix, you'll see that the deputy heads of finance and of the independent budget office say, we've got to value these condos and co-ops by reference to rental apartments, and sometimes there aren't comparables, and that leads to problems. And so it leads to gross undervaluation, and there is an option they can use. It's not that hard, honestly. The city has data on the sublet or sub-rental of condos and co-ops. It can use that data to help it figure out how much income these luxury co-ops and condos would bring in as rentals. It doesn't have to just shrug and say, we're going to pick a stripped-down rental in a different borough, and we're going to value our Fifth Avenue condo by reference to it. That's just insane.
I don't understand how that works, because you can't, if their position is you have to include rent-regulated apartments, you can't sublet a rent-regulated
Okay,
apartment.
let me start there then. There's two different things going on here, Your Honor.
Certainly not for market value.
Understood. There's two different things that are going on, right? And they both lead to gross undervaluation of the condos and co-ops. One has nothing to do with rent regulation or stabilization. It's just that they'll value a Fifth Avenue co-op by reference to a stripped-down apartment in the Bronx, just because it's the same size
Can I clear up
and the same
just a
age.
factual issue? The according to your pleading or your theory, the undervalued co-ops and condos are ones that are built pre-1974?
That's one part of them, Your Honor. So the
what
ones
happens with
that are
I mean,
affected
there's
by
some-
rent
just a sec-
stabilization
Just
are
a
the
sec.
older ones.
I'm just trying to understand.
Yeah.
So I walk around Manhattan, I see there are condo and co-op buildings going up now, right? Are those going to be undervalued?
Yes,
So
Your Honor.
why is that?
So, and again, this is in the testimony of those
Mm-hmm.
deputies I mentioned earlier. There are no good comparables, if you will, for the new luxury condos going up. And so instead of recognizing...
What about the condos and co-ops that went up 10 years ago? Why aren't those comparables?
The city believes it has to value a co-op or condo by reference to a rental apartment building. And so it
Well, there are
says,
also rental apartment buildings that are luxury rentals, right? That have gone up 5 years ago, they're going up now.
the city has acknowledged, again, in the testimony we're looking at, that often they can't find a comparable for the most luxurious condos and co-ops that are in the city. They can't find one. And so they pick one of a similar age and one of a similar size, and they say that's the best we can do. All we're saying is
Okay,
that's
all right,
not
so
good
that-
enough.
That
right?
helps me, because then that would suggest to me that your description of what they're doing is for a luxury co-op or condo that's going up tomorrow, they would look for a luxury rental that went up last year. They wouldn't look
They
at...
could find one
well,
in the
there-
same neighborhood, et cetera. Right.
Yeah, I mean,
Sure,
there
they
seem to
try
be a
to do
lot.
that. Now, as to the rent stabilization, that's a separate problem.
so but your bigger problem, if I understood it correctly, is that for the ones that are built in 1920, that are co-ops and condos, they're looking for rentals that were built in 1920 instead of comparing them to luxury rentals that were built last year.
Well, that's part of the problem, Your Honor, and it's certainly part of it. But the other part of the problem is that, and this is mostly pre-74, right? So they're looking at apartment buildings that would be rent stabilized under the ETPA. Y'all are probably more familiar with this than I am, but they're looking at that
As the comparator.
as the comparator. And a great number of those include many units that are rent stabilized. And the problem with that comparison is that given the locations, the finishes, the amenities, et
Is
cetera, that
that
exist.
choice compelled by state law?
No.
Okay.
That's what yes, exactly, Your Honor. They're just methodologically reflexively looking at an apartment building and saying, that one's rent stabilized, so we're going to pretend that this condo,
And
if
they
it were
always,
rental, were
they
rent
always,
stabilized.
if it's a pre-74 building, always look to a rent stabilized
They always look,
comparable?
sorry, Your Honor, they always look to a building they think is comparable in age and size, et cetera, and they say, well, that one has, 30% rent stabilized units, so we're going to judge this one as having 30 rent stabilized units. And the problem is, again, how the ETPA worked, and we're pre-2019, is that you could raise rents upon vacancy, and when rents exceeded a certain number, at one point it was $2,500 a month, then it was $2,700 a month, you exited rent stabilization entirely. And our proposition, again, our allegation in the complaint is that these luxury condos would have come out from rent stabilization years ago, and they shouldn't be treated as if they were rent stabilized.
Is there a stock of deregulated apartments of similar vintage? Because there seems to be a rationality to me of looking at 1940 and 1940. Is there a stock of deregulated housing that they could use as comparators?
Your Honor, I don't know if there were, and they were comparable in other ways, right? Same amenities, same types of finishes, in the same sought-after locales. We have no problem at all with valuing the condos and co-ops that way. The problem is that they're not doing it that way, and in not doing it that way, they're forgetting you have to look at the co-op or condo in question and look at how it would be valued if it were
Because
rental,
that...
not just generically.
The approach you are describing, I assume your argument is, would not be problematic under state law because it doesn't put the owner of the condo or co-op in a worse position based on ownership.
Exactly.
It's a comparison of the nature of the property itself. Has nothing to do with whether or not you're an owner or a renter. It's just bricks and mortars.
We couldn't agree more, Your Honor, and in fact, it's interesting that they cite DS Alamo. DS Alamo says you don't want to penalize co-ops and condos because they have a different ownership structure than rentals. We perfectly agree with that. The problem is they're giving them vast advantages as compared to the rentals with the methodology they're using. That's not what the law was ever supposed to be about.
Can I ask you about my hypothetical? Is that what you are talking about, or is it sort of, phantasmagorical, as they say?
Nothing is phantasmagorical. We're all in the world, Your Honor, but
Some might say the system is, the city's property
it is
tax.
complex, that's for sure. So, Your Honor, look, we are saying that if you've got a home in one borough that is
Okay.
valued at, and accurately valued at $500,000,
Yeah.
and you've got a home in another borough,
Yeah.
so let's say the first one's Manhattan, the second one's the Bronx, also valued at $500,000. We're not talking about the Constitution here, or at least we don't have to. Section 305 itself says all properties shall be assessed at an equal percentage of their value. So yes, they have to be assessed the same. And contrary to some of what I was hearing from my esteemed
I
colleagues.
guess I'm asking, is that in part what you're complaining about, that they are not?
Yes.
That example, which is just the
It's
most
hugely-
basic of examples.
It is what we're complaining about,
In
Your
part,
Honor,
yeah.
and there's a little bit of confusion here because you're being told, well, the fractional assessment ratio is applied and then there's a cap, but you don't figure out what the assessment is until after the cap has been applied. The cap, when they apply it, determines the assessment. And so when you look at an equal
I'm sorry, I
assessed
lost
and
you,
equal...
I lost you there.
Okay, let me
I may be
start...
the only one, but
Let me
help
start that all over again. Okay, so you first figure out the market value of the property.
Yeah.
Then you multiply
That's
it
my
by
500,000.
what they call, yes, and then you multiply it by what, again, George Sweeting or Michael Hyman, the heads of these things call the target assessment ratio. We called it earlier the fractional assessment ratio, what have you. You multiply it by that, so let's say it's 6%, right? And so that would be $30,000.
Yeah.
And you'd have a $30,000 number there, right?
Yeah.
But under the city's methodology, if the last year's assessment, and I'm not going to try to do math on my feet, but was more than 6% lower than that 30, then you've got to lower the $30,000 to get the assessment of your second property here. And what the result of that is that the two assessments will not be at the same percentage of their value. And that's why you have the violation of
Because it's
305.
historically baked in? Is that your point?
Well,
Because you're looking at the prior year.
Well, it's because the assessment, if you apply the cap as they've suggested, it truncates and lowers the assessment.
If one of those two properties had been $250,000 market value in the prior year and market value doubled, you'd only be able to increase its assessment and therefore its taxes by 6%.
Exactly, rather than by
50%, or 100%.
100%. That's
And
right, Your
and
Honor,
what's
and that
the-
leads to the problem that we've got here.
What's the error in the appellate division said you have to look at both of them together. You have to read them in concert and make them work as a scheme.
And
What's
we-
the error there?
So we agree with that as a rule, of course. The problem is that they didn't. What they did is they looked at 1805 and 305, and they applied 1805. As we've discussed, it can be done in two ways. You can comply with the caps either by reducing the assessment ratio or applying the caps individually. They did the latter. They said that was how you do 1805. But that was at the cost of violating 305, because now
So
you've
what's
got-
left, sorry, what's left of 1805 under your reading? What purpose, what function does it serve?
So, Your Honor, if I look at a statute's function by what it mandates, what 1805 mandates is that assessments do not go up by more than 6% in Class 1 or 8% in Class 2. If you lower the assessment ratio, that is one way to comply with 1805, and you have actually effectuated that command. The assessments did not go up. Now, why would they have cared about it? It's hard for me to get in the head of a legislator, Your Honor. They might have cared about it because in 1981, everybody was concerned about their assessments suddenly increasing. But what we know from this court's decision in O'Shea is that it's perfectly permissible for them to comply with 1805 that way by just lowering the assessment ratio. And if they try to comply with 1805 the way they're doing right now, they lead directly to a violation of 305. So in reconciling the two statutes, there's really only one way to do it that gives meaning to both, or complies with both, Your Honor, in the language I was using a moment ago. I think I've covered a good bit of what we were going to do. I wanted to note two other things. One is it's not a temporary fix. As we discussed earlier, you can continually lower the ratio. And in fact, if you look at the testimony to which my friend pointed of George Sweeting acknowledged that. He said it doesn't cure all the other problems with 1805. 1805 is inefficient. If you want to help people that are in their own home, why are you helping rich people as well as poor people? He was discussing all sorts of other things, but he agreed you can fix this problem by continually lowering the ratio. Next, it's absolutely the city's policy. Let's just be very clear on 581 and 305. And I think the state has now tacitly agreed that the city can do it either way it wants, in terms of how it wants to look at it. But one way is illegal, and it's the city's policy. It's not state law that's causing it. The city has tried to escape responsibility for years, pointing at Albany. It would be very helpful with this court to not only say it's the city's policy and it's illegal.
But only with respect to 1974 and prior, right?
Oh, we're back to, sorry,
I just
281?
want to make sure that.
We're on 281 now, Your Honor? Because
Yeah,
I was
yeah.
talking about
Oh, I'm sorry.
1805 as well.
Never mind, never mind.
It's more than just pre-74, just to
I
be
thought you
clear,
said
but
281.
even under 281. But, and lastly, FHA, I'm not quite sure what to make of the arguments that we were hearing, but if this court were to look at page 130 of the record, it shows the areas in the city that have, as a result of how the city is applying 1805 and 581, the parts of the city that have the highest effective tax rates as a result, who is burdened by all of this from an FHA standpoint, and it is the poorest areas of the city and is the areas with the greatest minority composition. So to the extent that the city was trying to suggest to you that these caps are somehow helpful to minorities in the city, that's absolutely off base. Our statistics that we've cited in our brief make that incredibly clear. Next, you don't have to show invidious discrimination. We're talking here about a disparate impact case, so whatever the city was thinking about that is just incorrect. No appellate cases on taxing systems, so that would suggest that a city could say you have to pay an extra tax if you sell your house to a black person, and the FHA would have nothing to say about that. That's crazy. There is no exemption for tax cases. There are no appellate cases that this court could look to that make sense on the merits, because Robinson suggested that you can't have a disparate impact case unless no white people are affected. That's clearly just wrong as a matter of law. The two cases that have looked at it and had reasonable analyses are actually Coleman in the first iteration, and the other one's Brighton Park out of Illinois, and they both went our way and got it right. I'm not going to take your entire afternoon, Your Honors, but thank you so much for hearing me out. I greatly appreciate it. If there's any further questions, I'm happy to answer them.
Thank you.
Thank you.
Counsel.